Hello, everyone, and welcome to today's webinar, Far-Reaching Russian Sanctions in the U.S. and an Unprecedented Speed in Enforcement. Before we get started, I would like to go over a few items. You will have the opportunity to submit text questions only to today's presenters by typing your questions into the questions pane of the control panel. You may send in your questions at any time, and we will collect these and address them towards the end of the presentation. Today's webinar is also being recorded. The information contained in this presentation is provided for general informational purposes only and is not intended to serve as specific legal advice. A copy of this recording will be emailed to you within 72 hours of the end of this presentation. I would now like to turn this over to Mark Franco, Yat Kasimi, and Dale Mullen.
Thank you. Good morning. Welcome, and thank you so much for joining us on this busy Friday morning for a virtual discussion on the scope of Russian sanctions, the risks they present to those of you watching and/or listening, and some key compliance considerations. My name is Mark Franco, and I'm a senior associate in the firm's Associations, Nonprofits, and Political Organizations Practice Group, where we provide general counsel services on a broad range of legal concerns, including the ones we'll discuss today. I'm joined by a couple of co-presenters who will introduce themselves shortly. But before they do that, let me take a moment to acknowledge the contributions of the team, both on the screen and behind the scenes. It takes the coordination of several folks to present the type of programming we have for you, and I hope our discussion not only provides you with some very valuable information, but also showcases the great team that we have here at Whiteford Taylor and Preston. Now, let me turn it over to Yat. Yat, do you want to introduce yourself?
Thank you, Mark. Good morning, everyone. Good afternoon, good evening, wherever you are. My name is Inayat Kasimi. I'm a partner in the DC office of Whiteford Taylor and Preston, and I'm also the head of the international practice at Whiteford. For those of you who know me, I'm originally from Afghanistan, and over the years, a large part of my practice involved working on Afghanistan-related issues, and as such, I've started doing a lot of work over the years on sanctions-related issues. And given what happened last August in Afghanistan, sanctions became a pivotal part of my practice. And interestingly enough, earlier this year with the developments in Russia and Ukraine, given that there was a lot of business activity between Afghan businesses and Russia and Ukraine-based businesses, I started to look closely at Russia-related sanctions. And these days, it's a very important part of a lot of folks in the business community. So I look forward to this opportunity today to share with you what we know and to give you a general sort of background and information on the sanctions that are currently in effect against Russia, Ukraine, and Belarus.
Great. Dale, do you want to take a moment to introduce yourself?
Certainly. Good morning, Mark. Good morning, Yat. My name is Dale Mullen. I am the head of the Whiteford Taylor Preston Regulatory Compliance, Administrative Law, and Government Investigations section. Every day I get questions from clients having to do with export control, regulatory compliance, and other matters of government enforcement and investigation across a host of medias. Everything from software and app development to the management of supply chain and export compliance regarding that. One of the biggest emerging threats and a multi-agency effort is the attempt to impose economic sanctions against Russia. One thing I'd like to point out from the very beginning is you may think, well, I don't do any business with Russia specifically, so I may not have any risk. What I've done for today is I've taken a look at the most recent, that would be 2022, specifically April and January of 2022 enforcement actions to help identify just a few areas of regulatory risk through the use of third parties. Because remember, if the third party is in violation and that third party is working on your behalf, you too are subject to an enforcement action. It's good to be here this morning. Thank you, Mark.
Great. So let's jump right into it, Yat. I have a question for you. The public, they see when sanctions occur, they usually start with some sort of executive order. And President Biden, since he's taken office, he's issued a number of executive orders related to Russia. And then those eventually get codified into some sort of federal regulation. Can you sort of describe how the whole sanctions regime works, the law behind it, and the role of the Office of Foreign Assets and Control, more casually known as OFAC? Can you sort of describe how all of that works together?
Yeah, absolutely. So in the US, sanctions are imposed by the President of the United States through executive orders, which are issued pursuant to 3 laws primarily. The International Emergency Economic Powers Act of 1977, the National Emergencies Act of 1976, and the Immigration and Nationality Act of 1952. The first 2 mostly deal with economic related issues. Sanctions are based on the first 2 laws, and then travel restrictions are usually done pursuant to the Immigration and Nationality Act. Now, as you mentioned, since April of 2021, a number of executive orders have been issued by President Biden. The first major one that was issued was April 15, 2021. That was 14024, which basically, if you recall, it sanctioned a number of individuals based on interference with US elections and also based on cyber attacks and cyber related activities. Now, that executive order has been expanded and it has been utilized in a number of directives by the Treasury Department, but also that has been supplemented by several important executive orders that have been issued since February of this year. 14065, which was issued in February, put embargoes and sanctions against the 2 regions that declared autonomy or that were supported by Russia in Ukraine. Then 14066 was issued in March, which basically banned petroleum and oil-related products import to the US. Then 14068 was issued again in March, which basically prohibited the import of fish, alcohol, luxury goods, jewelry, etc. to the US. And then most recently, 14071 was issued, which prohibited investments in Russia and financial transactions and export and re-export of goods to Russia. Now, keep in mind that each of these executive orders are then implemented by the Treasury Department, the Office of Foreign Asset Control, as you mentioned, who's responsible for sanctions. And OFAC issues directives pursuant to each one of these and kind of expand the scope of these. If you have followed in the media, the directives that have been issued by OFAC with respect to a number of individuals close to Putin, also known as oligarchs, many of them have been issued pursuant to Executive Order 14024, which dealt with cyber attacks and election interference. So that's the Treasury Department has kind of expanded the scope of that and applied the same executive order to other individuals. Also, OFAC from time to time issues frequently asked question responses to explain the scope of the executive orders and their directives, and the most recent one that was issued, in fact, was yesterday, which kind of prohibited all kinds of credit card transactions. So if you have a credit card issued by a Russian bank, it's no longer honored in the US. And similarly, if you have a US credit card, you won't be able to, you're not allowed to use it in Russia. So that's basically in general terms how sanctions are issued. At the moment, there are a number of them that are in effect. So there's an embargo on the 2 regions that I mentioned in the Ukraine. There's sanctions against Russian banks, including correspondent bank relationships. They've been kicked out of SWIFT. Sanctions against Russian oligarchs. These are individuals, well-known individuals close to Putin. there's sanctions or limitations, restrictions on access to capital from major Russian firms, blocking of Russian central bank, sovereign wealth fund, and Ministry of Finance assets, whatever they are, to the extent that they're reachable by the US. There were this Nord Stream 2 pipeline. Sanctions basically stopped the work on that and have put a lot of restrictions on it. Oil and gas import to the US. I mentioned the alcohol, fish products and luxury items. And the most recent ones are obviously investments in financial transactions and provision of services. So that's, in a nutshell, is the scope of what we're dealing with and how they're done.
Great. So Dale, you talked about a little bit about this in your introduction. I mean, we hear that these sanctions are on Russian oligarchs, on Russian banks, on Russian governmental agencies. So on this side of the Atlantic, I mean, how would you know if these sanctions even affect you, or if compliance with these sanctions would have anything to do with you?
You know, Mark, that's a great question. How would you know at the point at which you're risking violation of a sanctions? I would say first you need to look at your business deals. One wouldn't expect ordinarily sanctions were it not. And yeah, I'll ask you to talk about this in just a second about the sanctions lists, right? The specific individuals and companies. That's easy enough, and Yat and I can explain how to check those sanctions lists, where they're found, and some tools and resources available. But you may not really have a specific idea that you're dealing with an issue until you get to the end of, say, a merger and acquisition process. One of the questions that we frequently receive has to do with the 50% ownership rule. For those on the call, OFAC's 50% ownership rule is the rule that says that property and interests in property directly, and this is the part that's troubling, or indirectly, right? It's that indirectly part that poses the greatest risk for business, in my opinion, that property and interest in property of entities directly or indirectly owned 50% or more in the aggregate by one or more, and Yacht, this is something that you deal with every day, blocked persons. Those are considered blocked just because they are with that blocked entity or person. Now, what does that mean day to day? That means that in the diligence period, there's a new level of diligence that's required in international deal making, and with the advent of a Zoom era where all of us can literally be anywhere in the world transacting business, that means there's a new level of due diligence that's required behind every deal that includes a foreign national. Because that foreign national, whether it's a company or a person, could be backed by, supplied by, in business with, somewhere in the supply or business stream of commerce with a blocked person or individual. Yacht, I know that you're familiar with specific examples where the people themselves or entities may be blocked and not even know that they're blocked. And so it's difficult as these unfold. And remember that the 5 biggest enforcement actions for OFAC, and they are by no means the only agency. I'll talk later about one that the Federal Communication Commission issued a statement on this morning. It's unfolding so quickly and changing almost daily in the interpretations. But you asked about the risk, Mark. One example that I would give for the importance of due diligence is that OFAC itself urges people who are, and this by people I mean business entities as well, who are considering a potential transaction to conduct appropriate diligence on the entities that are the party or involved, not maybe just not a party, but also involved in a transaction, or with which the account relationships are maintained to maintain an ownership stake. As an example, I would talk about the case from April of 2022, April 1st, as a matter of fact. where the U.S. Department of Treasury, OFAC, announces a substantial settlement with a U.S. company, a New York-based company, that does nothing but provide business information and financial analytics. This particular company was put into a position where it had to agree to settle its potential civil liability for apparent violations of the Ukraine-related sanctions regulation, and this particular one was found in Directive 2, which is located at 31 CFR Part 589. And if any listener who wants to keep up and can't write quickly enough, please feel free to email us directly, and I'll send you the information that I have and some specific breakdowns on the enforcement cases. But in this case, it's a company that provides nothing but business information and financial analytics that falls into an investigation under OFAC having to do with Directive 2. This is Executive Order 13662 from March 24 of 2014. These violations occurred sometime, say, between August 2016 and October 2017, so not new, but they require, reissue, and then redate invoices to extend credit to a state-owned Russian oil company. I would not have thought in 2016, 2017, 2018, that this would even be a transaction that OFAC would be aware of. But today, it's one of the 5 leading cases for OFAC enforcement. Does that help, Mark, give a bit of context to the risk to business today from the expanding Russian sanctions?
Yeah, absolutely. You mentioned the word enforcement. So, enforcement obviously can be a big deal. I mean, what are some of the real implications that we're talking about when we intentionally or unintentionally fail to comply with these sanctions?
Sure, I think they range in seriousness. Now, in many of there are statutory penalties that are imposed. There are additional, Yacht, you had mentioned a few of these up front, and I'll throw it back to you. But they are also multiplied or mitigated in the enforcement penalty phase through the intentionality or the egregiousness of the conduct. Most federal statutes having to do with regulatory compliance, government investigations, and administrative law, they provide that different standards of penalties for those who simply say fail to apply for a license. And Yacht, that's something you know a great deal about. Failing to apply for a license, there's a period of self-reporting. Certainly, you should consult legal counsel before you tell the government you think you may have violated. I strongly suspect there are hundreds of companies today that are in either unintentional or accidental non-compliance who are pondering whether or not to make a self-report. It's almost always the right thing if done in the right way. But Yacht, what have you seen in terms of enforcement? I have the top 5 cases that I can talk about later, but I think it'd be good to hear about it from an actual practical perspective.
Yeah, so very good question. Now, obviously, there's the famous task force, which is set up in the Southern District of New York, DOJ task force, that is basically assigned to capture, identify, investigate, prosecute violators. They are not only tasked to go after individuals who are on the sanctions and blocked persons list, especially the oligarchs that are close to Putin, but also to go after those that violate and circumvent sanctions. This really expands the scope of the enforcement. So who are captured by this? And just to clarify one thing or to add to that, there's very, very close cooperation now between the US and a number of countries on this front. So initially started between the US and EU and UK and a handful of other countries. Now it seems to have expanded. There are a lot more European countries and a lot of other countries in other parts of the world that are part of this effort to enforce sanctions. Because we're not just talking about the US sanctions, we're also talking about EU sanctions, we're talking about UK sanctions. So there's really coordinated effort, aggressive effort to enforce this. Now, as Dale kind of mentioned, and you can discuss this, the scope of who this applies to is very, very broad. Now, normally in the past, you've seen sanctions imposed against Iran and a number of other countries where they targeted specific institutions and specific individuals. In this case, now it's much broader. It's basically any kind of financial transaction. It's any kind of investment. And it's not only, the scope is not limited to US persons, which is something that normally US sanctions apply to US persons. So a US person means basically you have to be a US citizen or a permanent resident or a US based corporation or a corporation that's owned by US citizens. So that's kind of the general area, parties that are captured by that. But in this particular case, it goes even further beyond that. So even if you are, let's say, a foreign corporation based someplace in Asia with no links in your own, if you're utilizing US technology to produce goods, you could be captured by some of the limitations imposed. So if you look at the more recent rules, especially on the commerce export control rules that are enforced by the Bureau of Industry and Security, it applies to foreign products and services as well. So it's not just US, to the extent that those products and services utilize US technology and US infrastructure and so on and so forth. So the scope is significantly broader. If you have, even if you think that you're not, you don't have any affiliations, direct affiliations with Russia, but if you're dealing with somebody who has work in Russia or has contractual relationships or sells goods to Russia, you got to look at that very closely, because you could be caught by the scope of some of the sanctions that have been imposed.
And yeah, I'd like to give two examples of that, again, that tie back to the point. It's broader now than it ever has been, and it's also deeper than it has been. Not only is there a multi-country effort to impose economic sanctions through punishing the companies that do and have done business, there's also a multi-agency enforcement action in the US. In the case that I just described, the April 1st, 2022 announcement for conduct that occurred in 2016 and 2017. Remember, this is a New York company that simply reissues and redates 4 invoices. They reissue and they redate 4 invoices for past due work for payments due. And OFAC determined that that particular company did not disclose that they had done that. And this was to the benefit of a company that served a Russian oil company, and that was a violation of, in that case, Executive Order 13662. It might be a good time to introduce this idea for a new point of risk, the most standard example. And we'll take just 2 companies. We'll call them Company Alpha and Company Beta. Let's say that a blocked person, your term from OFAC, Yacht, a blocked person owns a 50% share of Company Alpha. Company Alpha then owns a 50% share of Company Beta. If Company Beta is blocked, then Company Alpha can't do business with them. And we're just talking about fractional shares of different business. And I know when I handle these kinds of questions, I literally have to trace them out. If you have blocked person, we'll call it X. Blocked person X owns 50% of entity A. Entity A then owns 50% of entity B. Then entity B is blocked. And that's one of the ways that flows through. And when you start to think about this, you think, well, wait, I have suppliers. I have past due invoices. I have, in some of the 5 cases from 2022, it's purchase of goods or services from blocked countries. 2 of them were Cuba, obviously a Russian-friendly country. but these were acquisitions and purchases that were made ultimately from Cuba through a third-party Central or South American company on behalf of an American company. Those have resulted in OFAC enforcement. So people, when they conceptualize this, they think, well, I'm not buying oil from Russia. I don't sell anything or buy anything from a Russian oligarch. I probably don't have anything to worry about. And that is very much not the case. That ownership interest, remember that 50% rule that says that the property and interest in property of entities directly, and here's the risk, I'll say again, indirectly owned 50% or more in the aggregate by one or more blocked persons are considered blocked.
Yeah, so when we're talking about risk, I heard the term you threw out, multi-agency, and to me, that's sort of like an oh crap term, because then I'm like, okay, well, maybe I don't need to just be thinking then about the regulation sanctions under this OFAC regime. I mean, Dale, do you or Yat sort of want to talk a little bit about what other things we might want to be looking at?
Sure. You wouldn't think that a wireless company in the US simply doing business out of Montana would have anything to worry about. And Mark, that is, I think, a term of art, that oh no moment where you say, I think I have something to worry about on a Friday. This morning, I opened up the newspaper, one of the trade journals, to find that the FCC, not OFAC, not the State Department, not Commerce, not Customs and Border Patrol, but the FCC is seeking a $660,000 fine from a wireless company simply because it was there was an allegation made that this particular company was indirectly controlled behind the scenes. Maybe not even, it's too soon to say, the story just broke this morning, but there was some decision making going on behind the scenes by foreign nationals, including Russians, citizens of Russia, and also citizens of Cyprus, that has now drawn the enforcement arm of the FCC. And I have to tell you, it's been a long time since I've seen much vigorous enforcement from the Federal Communications Commission, especially dealing with sanctions. I think if you were to comb through, as I have for the OFAC, if you were to comb through the enforcement actions to find trends of risk, you would be really hard pressed to find an export control risk at the Federal Communications level. But that, Mark, would be one of those, as you so aptly put it, oh no moments on a Friday where you suddenly recognize, oh wait, I think that might be me.
So just to add to that, a couple of things. Now, for the folks that are not familiar with this, there are a lot of resources out there that you could go and look at. And I think the best resource is the OFAC website. And the Office of Foreign Assets Control has a website where they list all the blocked persons and specially designated nationals, SDNs, and you can search through that and see. Problem is that list might be a little bit behind. It might not be most up to date, because recently there was some individual that was who was added to the blocked person list, but then when I did the search on the system, it didn't show up. So I don't know if there's a delay there or not, but that list is growing every day and dozens of people are being added. So initially it started with a handful of individuals that were close to President Putin, a number of oligarchs. Now it is expanded to all of the members of Duma, the parliament. Now it's shareholders of banks, members of board of directors of various banks. There was a huge list that was added yesterday, which basically covered a number of banks. So that, the starting point, if you're doing anything with anyone from Russia, you got to go look at it and see, okay, is this the person that I'm dealing with? Are they, and obviously, even if it's something that you're doing with them that has nothing to do with Russia, you got to keep that in mind. Let's say if you have an investment in Europe and it happens that one of the investors or the co-investors is somebody who may be on the blocked persons list. The other challenge, which Dale kind of pointed to, these days, there's, because of the movements in recent months, there are a lot of movements of Russians out of Russia to places like Cyprus and Dubai and other places, and they've set up companies. So this further increases the due diligence requirement that you have to look at to make sure that you're not dealing with any SDN or blocked persons. Similarly, just in terms of resources, I think that the Bureau of Industry and Security of the Commerce Department has a lot of information there that you could go look at. All the executive orders that I mentioned, the directives, they're on OFAC's website. You can go through them. OFAC has daily press releases that you can sign up for them and you'll get them live. One of the interesting things that I noticed on BIS website is that they have sanctioned all US made aircrafts. So technically planes are not allowed to go fly to Russia if it's a Boeing aircraft. And they have a huge list of aircrafts and who owns them and that are subject to sanctions. So I think for folks out there who want to spend some time and do their own due diligence on those are some of the good places to start looking at information and gathering information.
Okay. So let me pivot slightly. We've been talking about compliance so far and potential violations, and we're talking about Russian sanctions today. But the U.S. has sanctions related to many different countries, and the severity of the sanctions, is very diverse. Sometimes folks can comply through a license or an exemption. Yeah, can you talk a little bit about how those work?
Yes, absolutely. Very good question. So if you are dealing with somebody or if you have dealings in Russia, there is one way to do what you're doing without getting in trouble. And that is to actually go and apply for a license to OFAC and get a license from them. So OFAC has two types of licenses. There's a general license that they issue. It's out in public and they for everyone, and to the extent that your activities fall under those general licenses, you can continue to engage in those activities. The other one is specific licenses, which you have to prepare your own application. Your counsel has to prepare it and submit it with respect to what it is that you're doing, and then OFAC reviews those and comes back to them. So far, OFAC has issued a number of general licenses. By and large, most of these general licenses deal with winding down transactions. What does that mean? That means if you have investments in a Russian corporation, the Treasury Department has given you 30 days for all the investors in Russian banks to basically get out, to sell their investments and get out. Some of these general licenses have already expired. Some of them are about to expire. They continue to issue some of those with respect to specific winding down transactions with respect to either investments in banks or Russian corporations or other contractual arrangements. So that's the biggest part of the general licenses that have been issued so far. There is a general license issued to nonprofit organizations, NGOs, that pursue certain types of nonprofit activities, whether it's in the area of human rights or democracy or healthcare. So I think you have to kind of look at that and see whether you fall under that or not. There is a general license for U.S. government-related activities. So if you're a U.S. government contractor and you happen to be doing something in the Ukraine and in parts of the Ukraine that are subject to embargo, or Belarus or Russia, you could be eligible. You could fit. Your activities could fall under the general license that has been issued for U.S. government. Similarly, there's one that's been issued for international organizations. So this is not necessarily NGOs, but this is the UN, the World Bank, and some of the larger international organizations. There's a general license that exempts them from the sanctions, so authorizes them to continue to do what it is they're doing. The most recent one, which is kind of unique, is the most recent license that was issued. It's a general license that was issued to Trans Capital Bank. I believe it was issued yesterday or 2 days ago, which authorizes transactions involving Afghanistan. So again, in light of the administration's efforts to support business activity in Afghanistan, they've issued a general license to a Russian bank to continue to provide banking services to Afghanistan-related transactions to the extent that they may involve export and import of food products to Afghanistan. So I think that that's the only one that's kind of unique out there. But beyond that, and that's specific to one bank. Beyond that, as I mentioned, most of the general licenses are very, very kind of focused on winding down transactions for people to have an opportunity to get out. Now, there may be a number of specific licenses out there. I know that a number of law firms and a number of corporations are divesting their interest in their Russian affiliates and Russian entities, so they may have sought to get licenses. Keep in mind that if you're dealing with somebody, even as a lawyer, if you have a client that's a blocked person, you have to get a license to actually get paid by them. So pretty much for everything that you need to do that involves transactions that are otherwise prohibited, you have to get a license. If it doesn't fall under a general license, then you have to apply and get a specific license, and you have to justify that. If you have doubts, OFAC also issues interpretive guidances. So you can submit an application, ask them for their opinion, their guidance on whether you should do something or whether what you do falls within the license or not. So that's something that that can also pursue. If the folks out there believe that what they're doing is involves Russians or Russian citizens, even if it's consulting arrangements, contractual relationships outside of Russia, and you have doubts, reach out to your lawyers, reach out to us. We need to look at that to see whether you need to get a general license from OFAC or not, because the last thing you want to do is be in violation of the sanctions rules.
So I think now, Mark, we asked for some specific questions. We've gotten a few, and we had some before the presentation. Would now be a good time? I think because Yat said and talked about the license, would now be a good time for that?
Sure, definitely. I think we can address those questions and also a couple of other very specific examples to give folks sort of a better idea of how to deal with some of these situations.
So yeah, I have my thoughts about one of the questions that we received, and I'll pose it to you in the form of a hypothetical, and I will remind anybody on the call, we're not your lawyers, and this is not meant to be legal advice. This is simply a discussion of the existing regulatory framework. But as we look at risk, Yat, you mentioned law firms. Law firms may or may not represent a blocked entity or a blocked party. Certainly, if you're a law firm with an office in Russia, you have to think about this question. And the question goes like this. My company has staff, and we'll say for purposes of this hypothetical, we treat those staff as independent contractors under either an interpretation of Russian law or of US law. So I have independent contractors who work for my company, and I pay those independent contractors who are located in Russia via wire transfer through a US bank. The bank is allowing the outbound wires to go through. Would that be an indicator that those transactions with Russian independent contractors working on behalf of a US company first question is this, do you see risk? Second question is, simply because the bank allows the transfer, would that be an indicator of OFAC compliance? And third, in a general sense, what do you recommend in a circumstance like that?
Well, very good questions, Dale, and I'm not sure I can answer 100% of those questions, and so I'll try to do my best. Number one, I think if you're providing services, depending on what type of services you're providing in Russia, or what type of services your independent contractor is what kind of activities you engage, that might in and of itself fall under one of the sanctions. So the most recent one, which is 140.71, prohibits all kinds of transactions and financing deals and other things, and I think it captures a lot of the services that law firms provide. So automatically you fall under that. To the extent that you're providing that to Russian entities and Russian individuals, that's another huge area of risk. 3, banks no longer make transfers because a lot of international transfers were done through SWIFT, and SWIFT has kicked Russia out. So if you have if you're doing moreover any kind of financial transaction involving Russia is pretty much prohibited by the more recent executive order. So it becomes very, very difficult. I was speaking to somebody who's a Russian citizen who lives overseas. Even though he lives overseas and he has bank accounts overseas, the US banks rejected transfers of payment to him for the work that he did outside of Russia. So I think banks are, for those of us that have dealt with banks, they're more conservative, they're more risk averse than even the scope of sanctions. So I think that some of the banks have kind of adopted the policy of absolutely no dealings with anyone having to do anything with Russia. To the extent that they have bank accounts, for Russian citizens, I think they're all probably frozen. Any kind of transfer back and forth, even to Russian citizens who are outside of Russia, some of the banks may not execute those transactions. So short answer to your question is yes, there's a lot of risk in that, and to the extent that folks are in that position, they need to start thinking about how to get out of that situation.
Yeah, again, every answer opens another question. We'll put in the context of a law firm. Let's say you're a U.S. professional services firm. We'll call it a law firm, put the lawyers in the hot seat, right? Give them an oh no moment on Friday. Do you as a professional services firm need to know the ultimate end user of the client all the way up the corporate chain? And I'm going to go out on a limb here and to give it even greater context outside the law firm. Let's say you have a lower tier subsidiary of a private equity fund. I'm going to go out on a limb and I'm going to say, yes, I think that using the ultimate beneficial end user of that service, and maybe you could talk about 140.71, but I think if ultimately what you do as a professional services firm benefits a blocked person, I do not think it's outside the realm of possibility that OFAC is going to look at that as a blocked transaction. What do you think?
Absolutely, absolutely. There's no question about that. I mean, to represent, first of all, there's nothing that law firms do represent blocked persons, but you have to get a license from OFAC in order to do so, in order to get paid. So let's say if you have a blocked person who happens to be living in Europe or in the US, who believes that he shouldn't be a blocked person, that he submits an application to OFAC to remove his name from the blocked person. He's entitled to hire attorneys and to represent him in those proceedings. But in order for the attorney to actually engage and get paid by that person, they have to get a license from OFAC. With respect to,
and I will say, in fairness to the U.S. government, they have been, I would say, reasonable in their approach to the issuance of licenses to afford, at the very least, legal representation. Fair?
Correct. Yes. Yes, absolutely. Now, with respect to representing clients who are based in Russia, it represents a number of other challenges. Obviously, if it's an individual, then it's a separate issue. But to the extent that you're representing a corporation that's engaged in a number of businesses and you're helping them, close deals or advising them on transactions, that significantly increases the risks associated with that, because then you could be violating other sanctions.
And Yacht, because you said closed deals, I'd be remiss if I didn't mention, because those in Russia with money have had their money frozen and their ability to invest frozen, they are certainly looking for other, the least generous way to look at it is fronts. Most generous way to look at it is investment vehicles in which to place their funding. Ultimately, if you had, say, a private equity firm, some investment vehicle not regulated by the SEC in the US or under some other regulation, we're OFAC to find out about your use of those funds from a blocked person. Now, this is the key, right? Through a blocked person or a blocked entity that looked like structuring or laundering or some other thing. That would definitely be the kind of a thing that OFAC would pay attention to, and I think in a hurry. Do you disagree?
Absolutely, I agree. I think the task force is basically set up to do exactly that. I think the task force is set up to make sure that nobody engages in any dealing that circumvents sanctions, that gets around sanctions, or that finds ways to avoid compliance with the sanctions. So, to the extent that you're a private equity fund based out of a third country, let's say Singapore, and if you engage in a transaction which involves the assets of a blocked person, then you violate U.S. sanctions. And trust me, these days, I think that the U.S. and European Union and UK and other countries will find ways to pursue claims, even though that's not necessarily a U.S. person. And there will be a link one way or another, whether it's the U.S. Transactions with U.S. funds or involvement with U.S. investors. So, the same fund could have U.S. investors. Keep in mind that we're talking about the compliance risks and what actions the U.S. government or other governments will take. This could also potentially trigger civil actions. So to the extent that a private equity fund in a third country violates the sanctions rules and engages in a transaction and then ultimately exposes them to fines and settlements with the U.S. government, that could also trigger significant civil liability by other shareholders against the management for violating the sanctions. So I think that we're going to see the impact of these sanctions for years to come, both in terms of enforcement initiatives by governments, especially the U.S. government, but also in the form of all kinds of potential lawsuits in different forums.
Yeah, let me jump in here for a second. So where do these concerns then leave us with contractual obligations? I mean, if you have, let's say you have repayment obligations under a loan agreement, or you've provided services and are owed payment, sort of what do we need to be thinking about in those situations?
So I think
Sure.
The starting point would be to look at the contractual arrangement, see what it is. And I think this is a good time for whoever's in that position to consult with their counsel and come up with a strategy of how to, one, comply with the sanctions regulations, and two, protect themselves against potential lawsuits or defaults that could emanate from that non-payment or non-compliance with contractual arrangements. So I think that they need to look closely at the contractual obligations, what laws govern that, and what it says, and what the force majeure provisions say. So I think if anyone is in that position, the best thing for them to do would be to seek counsel immediately.
And I would say too, one of the other things, and there's an awful lot of bad news, I think, in this call, and that's okay. That's identifying the risk is a big part of it. So what do you do about it, Mark? What do you do about that risk? In the instance that you just described, one of the best ways to mitigate the risk is to go back with your counsel and look at the enforcement action. It's the one that I mentioned, and I won't name names, not knowing everyone who's on the call. I don't want to embarrass or offend any U.S. company, because all of the violations so far have been non-egregious. And so these are just folks that made mistakes. But I would say we would go back, we would look at the reason for the April 1st enforcement action. I would say that we would identify all of those things in that particular case where the violation involves reissuance and redating multiple invoices on behalf of a state-owned Russian oil company. And I would say then we don't do that, right? We don't do that. We do something else. It may appear like getting a license. It may look like seeking a determination. But there's ways to avoid walking directly into the same mistakes that other people have made. Second good news is this: being aware of the risk, understanding the risk. Let's take the private equity firm example. Question came up during this session. Well, are you really saying that we need to get a list if we suspect, I would assume, if we suspect that there may be some Russian or bloc person's involvement, are you really suggesting that we have to get a roster of all the PE, all the private equity investors? And I would say yes. Yes, I would say that that's the case, because remember, OFAC urges those considering a potential transaction to conduct appropriate due diligence. And I think that if you suspect that you might be dealing with investments with blocked persons, yeah, your point is well made. That is exactly what the task force in the Southern District of New York is looking for. And I think that they would be all over a transaction like that. Additionally, I think that those kinds of transactions are opportunities to examine the account relationships and also the relevant ownership stakes, so that you can understand the risk that you're undertaking in unknowingly participating with a blocked person or entity. So those are just a few things, Mark, on the prospective side of a deal side. And then you had mentioned the collection part. What do you do about that? There are some things, yes.
So let me ask by way of another example. So you're a U.S. oil and gas services company, and you have a significant contract in Iraq to provide oil and gas services to Iraqi National Petroleum Company. And you have a subcontractor, which is an Iraqi company that provides certain services for you, which happens to be a JV between an Iraqi company and a Russian company that's affiliated with a Russian oil and gas company. Dale, what do you say?
Give me the entities again, yeah. I want to understand that. Make sure I understand who we're dealing with.
I mean, basically, dealing with foreign JVs where Russian companies and Russian bloc companies and bloc persons have an interest in automatically triggers the sanctions. So basically, in that case, you have to stop paying to the Iraqi company, because that payment could be deemed a violation of the sanctions. And I think
that's an easy question, yes.
Especially with folks that are doing business, that have contractual arrangements, that are providing services outside of the US, whether it's in the Middle East or Asia, wherever it is, they need to look at the second and third layer of who it is that they're dealing with. And I think that that's what complicates the situation and makes this thing very difficult and risky.
Direct, and you couldn't be more right. Yeah, I agree 100%. I would return in closing to the first thing that I started with. The part about this that makes it so complicated, at least from my perspective, is the indirect, unknown involvement of foreign actors who are on the blocked parties or entities list, right? It's that indirect, remember the 50% rule, that the property and interest in property of entities directly or indirectly owned 50% or more in the aggregate. It can be a combined set, but indirectly under the 50% rule means one or more block persons that are 50% more owned in the aggregate by a block person. It'd be difficult to imagine any deal that I've worked on where you didn't have, if assuming that those people weren't blocked at the point that that transaction occurred. If I were to look at that same transaction today, I would be very concerned about the actual ownership given the state of enforcement at OFAC right now.
Okay. All right. Before we close, there's one other thing I wanted to ask about is, do we need to be thinking about anything else beyond sanctions? For example, we hear now in the news about Russia taking its own actions that potentially could affect U.S. businesses and persons. How much do we need to know about sort of how that's going on?
I think that's becoming a very legitimate concern especially for entities that have made significant investments in Russia, and for institutions that have significant presence there and has been there for many, many years. There are a couple of things out there that have been mentioned that really causes concern. One is it appears that there are some retaliatory actions by Russian government against those that comply with US sanctions or with European Union sanctions or UK sanctions. So if you are a partner in a US law firm's office in Moscow, and you start complying with US sanctions, that exposes you to certain risks. And I think that a lot of institutions that I've talked to are kind of concerned about where that would go. The other major sort of threat is potential nationalization, has been mentioned. So to the extent that there's a flood of Western firms leaving Russia, it would not be out of the realm of possibilities for Russia to start engaging in some kind of extraordinary action to either nationalize their assets or something. So it's another worry. And then the third and the most recent one is apparently there's some actions on Russian side to delist Russian companies that are listed on various exchanges in the US and in London, other places. And again, that's another retaliatory action, which is not very clear where it's going to go. There's not a whole lot of information about that out there, unfortunately, but it's something to keep in mind. And how you divest your interests in Russia, how you unwind and cut ties is also something that you need to be very careful about, because what you don't want to do is expose, your affiliates and associates in Russia to risks, to some of these risks.
And I would say, Mark, in answer to your question, that when you look at Russia, say 2019, going into 2020, and certainly before the Ukrainian war, something in the order, according to the Bureau of Commerce, something like 66,000 US jobs directly tied to the Russian economy, something like our 40th largest trading partner in terms of US exports to Russia. It's like going to a family picnic. You're going to know a lot of people that you didn't know you knew. And we really didn't look at these relationships too much. And if you go down one level deeper, China has a very deep and had traditionally had a very healthy economic tie to China. And certainly we have good economic ties to China as well. Unpacking who is and is not still permissible to trade with, to regular companies who have to deal with these questions every day with the looming specter of regulatory enforcement, is difficult. It's difficult. And I hope that we've been able to help identify a few points of risk and maybe point towards a few solutions. I'll say again, I'm happy to share all of the information that I've given today, as well as the full details as published at the OFAC website, having to do with the enforcement actions so far, so that the listeners and those in the business community who do make America move through jobs can understand the risk, mitigate, and still continue to do business.
Okay, 1 minute left. We have any parting thoughts for our attendees? Sort of what do they need to be doing now? Where do they start? Are there things that they should be looking out for?
Well, they got to start with examining what it is that they're doing and if there's any link to Russia. So whether they're US-based businesses or international companies, whatever they're based, let's see if they're dealing with any Russian counterparties, Russian contractors, subcontractors, suppliers, purchasers. I think if they do, then they need to start looking closely at the potential impact of sanctions to make sure that they're not violating sanctions. They need to consult with their counsel. That's the best advice we can give them at this point.
And I would say 3 letters, KYC. Know your client, know your customer. Know your client, know your customer. That's the beginning of a good due diligence program.
Great, thanks. And thanks to all the attendees for joining us today. We hope we provided you some valuable information, and feel free to reach out to any one of us or any person that you've been working with at Whiteford, Taylor, and Preston. We hope you enjoy your weekend and have a really nice rest of your Friday.
Thank you, Mark,
Thank
Yacht,
you.
and Dale. Again, as a reminder, attendees will receive a copy of this recorded webinar. And like Mark said, if there was a question that we were unfortunately unable to get to, please feel free to reach out. On behalf of Whiteford, Taylor, and Preston, thank you for joining us today. Take care.